The last bill on the agenda is House File 3625. I will move that House File 3625 be recommended to be re-referred to the Judiciary, Finance, and Civil Law Committee. Would you like me to move the A1 amendment, Representative Stevenson?
Yes, please.
Okay, I will move the A1 amendment. Is this just to put the bill in the shape you'd like?
That's correct.
Okay, any discussion to the A1 amendment? All right, seeing none, all those in favor, please say aye. Aye. Opposed? Motion carries. The amendment is adopted. Representative Stevenson, to your bill as amended.
Thank you, Mr. Chair, members of the committee. This bill updates the deepfake statutory language that was adopted last year on a bipartisan basis. Last year, we were nation leaders in taking action to combat the threat of the influence of deepfakes in our elections. Since that legislation has passed, the need to be aggressive in combating deepfakes has been illustrated pretty dramatically in our presidential election, where deepfakes using what purported to be the voice of President Biden were used in the New Hampshire presidential primary process. Deepfakes are here, people are doing them, and we need to be very real about how we address them. So we did pass great deepfake legislation last year. This bill updates it just a little bit in a few ways. First of all, it adds forfeiture of nomination or office as a penalty for a candidate using a deepfake in violation of the statute we passed last year. It modifies the definition of deepfake to add content that has a fundamentally and materially different understanding of the substance or meaning of the content of the speech or conduct compared to the unaltered original version. It takes, after adoption of the amendment that was just adopted, the deepfake statute is only applicable 90 days before an election, general or primary. We add political party nominating convention, presidential primary, local primary, special elections to that list. And then we allow for injunctive relief, or just clarify the nature of the injunctive relief, injunctive or equitable relief. That's the bill.
Thank you, Representative Stevenson. I have two testifiers on the bill. Secretary of State Steve Simon, if you could please come forward and identify yourself and proceed with your testimony. Welcome to the committee.
Thank you, Mr. Chair and members, for the opportunity to testify in favor of the bill. Steve Simon, Minnesota Secretary of State. I want to thank Representative Stevenson as well for his national leadership on this issue. He, and I'd say through him, the state of Minnesota, have drawn national attention to the issue of AI-driven disinformation in the election context. AI, which powers deepfakes, I would say is not in and of itself a threat to our elections or our democracy, but it is an emerging and powerful amplifier of existing threats such as disinformation. If AI-generated deepfakes are used to misdirect voters, the result could be disruption and disenfranchisement. In the hands of those who want to mislead, AI tools can represent a revolution in their ability to cause harm and corrode faith in our system. And let me just give you a couple examples. One a little bit old, one more new. The one that's a little bit old, not so old, but was a leaflet I remember seeing here at the legislature that was handed out in neighborhoods in Milwaukee on doors for the 2000 presidential election. And that leaflet, good old-fashioned Xerox leaflet, said something like this. It said, hey, voters, remember, next week there's a big election, presidential election. If your last name is A through L, you vote on Tuesday. If it's M through Z, you vote on Wednesday. That was 2000, just a quarter century or so ago, paper leaflet. Now imagine that same leaflet or the same content in the leaflet, the same attempt to misdirect voters on an election-related matter, in this case, election administration, the rules of the road. Now imagine instead of that quaint, old-fashioned leaflet, now it's a deep fake of the mayor of Milwaukee, or a popular Milwaukee Bucks basketball player, or a well-known faith leader. You get the idea. So it just amplifies the ability to get that message across, which is why the stakes are so high. The most recent example, I think, is the one that Representative Stevenson alluded to, which is the Joe Biden robocall. And I don't think we're done with that this year. We have not, to my knowledge, seen an example of that in Minnesota yet, and I hope it stays that way. But we can't just bank on that. So last year, with broad, I think nearly unanimous support, you and the legislature passed the underlying bill that has really turned heads across the country. I can tell you that other secretaries of state, other states, red, blue, and otherwise, are very interested in the approach that Minnesota has taken. So while Congress has been debating sort of around the edges on disclaimer requirements, you in Minnesota sailed way past that debate and said, we're not going to do disclaimer requirements. We're going to enact a limited but controlled ban within 90 days of the election if there's no permission of the depicted person and if it's done with the intent to influence the outcome of an election. So this year, this bill, there's a chance to tweak and improve the law. I leave the particulars to you, but I support the direct action that this bill and the underlying law represent. I think, though, that laws like this, the underlying one, make me cautiously optimistic about AI and deepfakes. It's a problem, it's a challenge, but we've faced technological challenges before, as we all know. I mean, the arrival of computerization in the 80s was seen at the time as maybe a challenge. I wouldn't say so much a threat, but a challenge to election administration. Likewise, the arrival of the internet in the 90s, social media in the 2000s and 2010s. So each time we in Minnesota and nationally have adapted, and some of that adapting was done through legislation, but some of it was just human behavior. So I think we can do that again. I just want to point out very briefly that legislation alone is not enough, at least in my opinion, to meet the challenge. Election officials throughout the country are renewing the call to the public to really seek out and look at trusted sources of information to minimize the risk of deepfakes and other mis or disinformation taking hold. That could mean our website, mnvotes.gov. If someone has a question about who's eligible and where to go and where the polling place is and what the hours are, our website's an example. Or if you don't want to go there, you can go to your county or your city. I just want to thank you for your time, your attention, and your bipartisan leadership, all of you, on this issue. Thank you.
Thank you, Secretary Simon. The second testifier is Mary Hartnett. If you could please identify yourself and then proceed with your testimony.
Mary Hartnett, Clean Elections, Mr. Chair, members of the committee, Mary Hartnett, Clean Elections, Minnesota. Mr. Chair, members of the committee, as I said, my name is Mary Hartnett. I'm the Executive Director of Clean Elections, Minnesota, a nonpartisan, nonprofit organization that educates and advocates for an inclusive and healthy democracy. Last fall, we hosted a forum on the threat of artificial intelligence and election interference with the Brookings Institution. This is an issue that is very important to us. Deepfake AI is turning the 2024 elections into an unprecedented test on how to police deceptive content that dupes voters. Last month's robocalls, as we mentioned, with a simulated voice, encouraged voters not to participate in the New Hampshire primary. It's one example. Moreover, we believe that faith in elections is an essential democratic norm, and deepfake AI in elections can lead people to reject the very norms that we need for a functioning democracy. The World Economic Forum issued a report this year with the Zurich Insurance Group. They surveyed over 1,400 global risk experts, policymakers, and industry leaders about their biggest global concerns. AI-derived misinformation and disinformation and its implications for societal polarization ranked ahead of climate change, war, and economic instability in its top 10 risks over the next 2 years. There is no truth in advertising rule in political advertising. With paralysis in Congress, states like Minnesota are left to put up as many guardrails as we can to mitigate that threat. This bill, the provisions of this bill strengthen last year's deepfake bill, and Clean Elections Minnesota urges you to pass House File 3625. Thank you to Representative Stevenson for introducing the bill, and to all of this committee for your bipartisan work and to your commitment for strengthening our democracy.
Thank you for your testimony. Are there any members of the public who wish to testify on this bill? Seeing none, I have an A2 amendment. I believe that might be yours, Representative Torkelson. Would you like to offer it?
Thank you, Mr. Chair. Yes, I'd like to offer the A2 amendment.
Okay, the A2 amendment has been offered. To your amendment, Representative Torkelson.
Well, thank you, Mr. Chair. The A2 amendment relates to the severity of the penalties that are being changed in this bill. I feel, the this is kind of new territory, this deepfake work. As has been described by others, we're kind of ahead of the curve in many ways. And it's just the underlying bill has had bipartisan support, both here in committee and on the House floor. However, I would like to hear from the author, his reasoning behind having such severe penalties in place for something that we're really, at this point, kind of exploring. It seems like we're going very far without a complete understanding of how deepfakes really might function in the real world. So I guess my question is to the author as to why he's gone this direction.
Representative Stevenson.
Thank you, Mr. Chair. Thank you, Representative Torkelson. Appreciate the question. I think forfeiture is a significant consequence, but it's worth noting that the legislation that passed last year establishes that violations could be a misdemeanor, gross misdemeanor, or felony, depending upon the exact nature of it. And those are, I would argue, very severe consequences. And a felony conviction might even be more severe than disqualification from office. I also would add that I think that while I support having the availability of forfeiture as a remedy, I think that most people would expect that most deepfakes won't be done by a candidate or candidates committee, but by a PAC or an outside special interest group. In which case the forfeiture wouldn't come into play, because the forfeiture only occurs if it's the candidates committee or that's done with the candidate's consent or knowledge. The candidate would have to be involved in the deepfake in order to trigger the forfeiture. So if a political party or some other entity runs a deepfake as an independent expenditure, right, without the candidate's knowledge, we're not talking about forfeiture in that instance. But it seems to me that if you have a candidate engaging in knowingly serious illegal behavior in order to win elected office that is of a degree so serious that 200 of 201 legislators last year voted to make it potentially a felony, that forfeiture of office is an appropriate remedy in that instance.
Representative Torkelson.
Thank you, Mr. Chair. Thank you, Representative Stevenson. So, as you know, I'm kind of a old guy and a Luddite. I don't profess to understand artificial intelligence very well. But it seems to me there is some potential that the artificial intelligence could be used to try and fake the indiscretion, right? That somehow we produce artificial intelligence that blames a candidate for using artificial intelligence, and you've got a two-step process here of trying to prove who did what, and taking people off the ballot is pretty severe.
Any comment, Representative Stevenson?
Thank you, Mr. Chair. Representative Torkelson, that would be concerning if somebody used a deep fake to try and prove that a candidate used a deep fake in a election. I would note that in order to violate the deepfake statute, you have to prove, and it's in this case, a criminal act, right? So you have to prove beyond a reasonable doubt that the candidate knows or should have known that the deepfake, that they disseminated. First of all, you'd have to prove beyond a reasonable doubt that they disseminated it, that you have to prove that they knew or should have known that it was a deepfake and that they did it with the intent to injure a candidate or influence an election. So that's a pretty high bar, and I think that if that has occurred with regard to a candidate, disqualification is appropriate.
Representative Torkelson.
Well, thank you. Well, it's my feeling that the remedies you have in the original bill are adequate, and this is going a step too far at this point in time. It may be down the road as we venture on this path of trying to understand how deepfakes may or may not be affecting elections, that this may be necessary down the road. I just think it's, at this point, going a bit too far, and I would appreciate a green vote on the amendment.
Representative Qualm to the amendment.
Thank you, Mr. Chair. To the author, what current offenses in the state of Minnesota disqualify a person from being elected or holding an office?
Representative Stevenson?
Mr. Chair, I'm going to have to phone a friend. I don't know if Mr. Gehring or someone from House Research can answer that question. I don't know the answer.
Yeah. Matt Gehring?
Mr. Chair, Representative Quam, so if you look at sections 1 and 2 of the bill, you see that there's existing law related to forfeiture of nomination or office, and that is in the Fair Campaign Practices Act. So it's the types of acts that relate to the conduct of campaign. So in that chapter are things like bribery, false statements, and other sort of similar types of acts that are fair campaign practices violations and then would trigger potentially these forfeiture provisions if the person is convicted of those.
Representative Quam?
Thank you. It would have been nice to have had that material or that list so we understand, similar justifications for this discipline. Now, to the author, a campaign committee. I know a lot of people that part of their campaign committee would be some teenagers that have skills in social media, internet, et cetera, because they grew up in it and it's natural. So a teenager involved in a campaign committee who's used to generating stuff decides to do a funny, quirky thing, and it gets out and is classified as a deep fake because it's a sarcastic thing about the opponent. The candidate could very well not only not know, but not understand what that person did. And so I would think that there should be some clarifying along that area to preclude, because if we have non-clear parameters, a judge, jury, DA, et cetera, can go beyond what our intent is. Legislative intent doesn't mean a whole lot to the judge unless it's clearly stated, because we repeatedly have to go back and visit and clarify language because a certain judge totally went outside our legislative intent. I've worked with Representative Pinto on human trafficking for just such a case years ago because we thought it was clear and then it was interpreted differently. The penalty is severe enough to where I would hope we would be very clear or much more defined to prevent someone suffering because the teenage tech guy on your committee decided to do something funny. Because if you look on social media, there are a lot of little things that pop up there that seem to be normal, but in this instance have huge ramifications. So that's why I think we shouldn't go forward with this bill unless we've got the amendment on it, because I think the intent is understandable, but the execution in the current language doesn't quite meet the level that we need. Thank you.
Thank you, Representative Quam. You did tie it back to the amendment at the end there, so. Yeah, any
Well,
response?
Mr. Chair, I think,
Representative Stevens?
Representative Crum, if you look at the language in the bill, your concern is directly addressed. There's no liability for a candidate if they don't know or aren't immediately involved. And so look at subdivision 1 of the language. There's two possibilities here. Either the candidate has to be directly found guilty, or it was committed by another individual with the knowledge, consent of the candidate. So if the teenage tech guy does something without the knowledge of the candidate, there's no liability. So the guardrails you're looking for are in the bill explicitly. Furthermore, it all has to be predicated on a criminal conviction, and the underlying bill or the underlying statute that's already law requires as an intent of a criminal offense, so proof beyond a reasonable doubt that the candidate knew or should have known a specific intent. So I think that the concern you're raising is already addressed by existing law and the statutory language in the bill.
Mr. Chair.
We do have the ability to go a few minutes late, just so members are aware. I'd prefer not to go super late, so if members could keep their questions brief. And we are still on the amendment.
Right.
Representative Quam.
The knowledge of, so if the line of questioning is so-and-so your tech person? Yes. Are you aware that they were doing your website and social media? Yes. Did they have authority? So I can see creative questioning and the right jury or judge deciding that they need to determine that he's responsible or that he should have known, and therefore they're going to go ahead and do it. I want to firmly prevent, the severity, and I can see, because we've seen it on the federal side of where they just don't like the candidate, so it doesn't matter, and they just go ahead and do it. And they've fortunately had some of those overturned by higher courts, but in Minnesota, since this is specifically to Minnesota, I have concerns.
Thank you. Seeing no additional questions, we are on the, to your amendment, Representative Torkelson.
To the amendment, yes, Mr. Chair, thank you. Representative Stevenson, we have talked about this deepfake issue mostly as an issue of doing something that would diminish the candidate that you're opposing. What if I use deepfake to enhance my own candidacy? Could I be held responsible and potentially be convicted and removed from the ballot?
Representative Stevenson.
I think that if you used a deepfake that was designed to make you look better, that could potentially fall within the realm of what is defined as a deepfake. If you look at the definition, not even what we're adding in this bill, but the underlying language says, believes that a speech or conduct of an individual who did not in fact engage in such speech or conduct. So if I made a deepfake showing me rescuing a cat from a tree, right, when I didn't in fact rescue the cat from the tree to make myself look heroic, and then disseminated that within 90 days. No, but it says without the consent of the depicted individual. And so, since I am the depicted individual, unless you can say the cat didn't. So I think it would depend, is the answer, Representative Torkelson. The example I was going down, I was kind of tracking with you there, and I got thrown a loop by this consent element. I think it's conceivable that you could have a sort of pro-candidate deepfake that violates the statute. I do think that's possible. Like maybe if you fake the endorsement if I tried to claim, if I ran a deepfake ad claiming that you endorsed me in my reelection campaign without your consent, then perhaps that could fall within the realm of the deepfake statute, yes.
Representative Torkelson.
Well, thank you. No one would believe that, but. But again, I'm just trying to back up my reasoning behind the not going so far with the penalties here, because I think some of this is somewhat unexplored territory. And taking people off a ballot is weaponizing this in a way that I think is beyond what we really were thinking about last year when we voted for this. So I would resubmit my amendment and ask for a roll call, Mr. Chair.
Okay, thank you. The A1 amendment has been moved and a roll call has been requested. Are you ready on that? Okay, I'm sorry, this is the A2 amendment, the A2 Torkelson amendment. So the roll call has been requested. So the clerk will take the roll on the Torkelson amendment.
Chair Freiberg.
No.
Vice Chair Greenman.
No.
Minority Leader Torkelson.
Aye.
Representative Agbaje.
No.
Representative Altendorf.
Aye.
Representative Bonner,
No.
Representative Bliss,
Yes.
Representative Coulter,
No.
Representative Davis,
Yes.
Representative Frederick,
No.
Representative Purcell,
No.
Representative Quam. Aye. Representative Vernig.
No.
There being 5 ayes and 8 nays, the amendment is not adopted. Any final questions about the bill? Hopefully not, because we're past time. Okay, seeing none. Any closing remarks, Representative Stevenson?
It's a good bill. Please vote yes.
Okay, thank you. With that, I renew the motion that House File 3625, as amended, is recommended to be re-referred to the Judiciary, Finance, and Civil Law Committee. All those in favor, please say aye.
Aye.
Opposed? No. Okay, the motion prevails. The bill is on its way.